Welcome to our webinar where we will discuss how the GDPR will affect marketing agencies. We're going to go ahead and get started now. And so the first thing we want to talk about are just the topics that we're going to cover today. What is the GDPR? Ultimately, who's affected by it? And then if you are affected, how do you avoid fines? What data can you store? How can you collect data? How long can you actually retain that data for? And who can you share the data with? And we went ahead and collected some questions prior to the webinar, and we will answer those at the very end. Just a quick disclaimer, this is not legal advice. This is our understanding of the GDPR and how it will affect marketing agencies. So be sure to consult a legal advisor before you, before you confirm that your business actually is compliant with the GDPR. So what is it? The GDPR is the General Data Protection Regulation, which focuses on the privacy and data protection of individuals in the European Union. The law pertains to companies and organizations that interact with or process personal data about individuals in the EU, regardless of where the company is based. In an effort to protect the privacy of individuals, the regulation specifies how companies can collect data, what data can be collected, and how that data can be processed. The new regulation goes into effect tomorrow, May 25th. So let's talk about who's affected. Chances are, if you're a digital marketer, you're affected. If any of these bullet points are true, you must comply with the GDPR. Your company is located in the European Union, your company does business in the EU, or you collect personal information from an EU citizen. That means if you collect as much as an email address from an EU citizen, even if your business is located in the States or Canada, you're obligated to comply with the updated regulation. This is also true for any sort of personal identifiable information, even if it's not as cut and dry as an email address. For example, if you're using tracking cookies and that user ID from the tracking cookie can be tracked back to an individual user, then you must comply with the updated GDPR terms. And we'll talk more about tracking cookies later in the webinar. And so why should you care? Why does it really matter for your business? Well, in the most severe situations, not abiding by the new regulation can result in a fine up to 20 million euro. Essentially, the way they laid out the framework for fines is it's either 20 million euros or up to 4% of your total global turnover in the previous fiscal year, whichever is higher. And that, again, is in the most severe situation, but it's not really a risk that you should be taking. One, like obviously you don't want the fine and you don't want to pay the money, but two, you should be looking out for your users and individuals' data protection and their privacy. And so I think it's a step in the right direction. I think companies should be looking to be more transparent about how they use data and really being thoughtful about what data they're collecting. However, it's tough circumstances with the GDPR actually being rolled out tomorrow. It doesn't give a lot of time for most companies to be compliant, but I think it is a step in the right direction overall. Okay, so avoiding fines. Let's start with your terms of service. Ensure that your terms of service and privacy policy accurately reflect how you use an individual's data. Only use data in ways declared in your legal agreements. For example, if your legal agreement states that you only collect email addresses to send them newsletters, but then you use those email addresses to create a custom audience on Facebook for ad targeting, you're violating the new regulation. Of course, that's the same for using the email address for really anything other than what you said you were going to use it for, which in this case was sending newsletters. The second bit is only collect data necessary for the service. So this means that you can't collect data for some functionality that you intend on adding in the future that isn't currently in your legal agreement. This one's important. I know Facebook has been cracking down pretty heavily on this in terms of app developers. With the Facebook platform, you have to request specific permissions in order to access the API. and they won't allow you to access any data that you're not currently using within your application. Even if you intend on adding it the next day, they won't give you access to that data until you've proven that you are using that data in a responsible way and you are not violating any of their terms of service. Collecting data. I think this is the part where most people, most businesses will probably not be compliant. And I think this is where a lot of people will need to take a look at their website and kind of comb through the registration process or the opt-in process and really make sure that they are following everything properly to avoid fines. And so the biggest thing is users must give affirmative action. It's no longer okay to collect email addresses via lead gen form without giving explicit consent from the user. Previously, a lot of people would just take implicit consent. You've probably seen things like by clicking continue, agree to our terms of service, or by using our website, you agree to our cookie policy. That's no longer possible after tomorrow with the GDPR rolling out. So users must give affirmative consent, which means that the checkbox must be unticked by default. You can't have a pre-ticked checkbox and just have the user click next step. It needs to be unticked by default. You also can't collect any data until consent is given. So this checkbox should be on the first step of any registration or lead gen form that you have. Facebook and LinkedIn have added optional consent boxes to their lead ads. So be sure to enable this feature if you run any lead ads after May 25th. Collecting data. The wording must be informed, specific, unambiguous, and revocable. That's directly from the GDPR document. And so I think the most interesting part here is the fact that data must be revocable. I'm assuming most existing systems don't have an easy way for users to, update or remove any kind of personal information. So I'd imagine that's going to be a lot of effort moving forward for most teams. So you need a way for users to opt out of your service and take their data with them. It's no longer okay if someone says, I don't want to receive emails anymore, or I don't want to use your service anymore, and you just kind of change a flag in the database saying they can't access your service, but you keep their data. That's no longer okay. You actually have to wipe clean all of their data. We'll talk about data retention a little bit more in a second to kind of discuss how long you can actually keep the user's data for. And again, users also need a way to review and update what personal data you store about them. So this is on the topic of data retention. How long can you actually store the data for? And it's a bit of a blurred line here. It's something that I think is going to get worked out over time, and it is really dependent on your service and your use. But in general, the GDPR states personal data must be kept no longer than is necessary for the purposes for which the personal data are processed. So what does that mean? Well, it really depends on what service you offer, again, but for marketers, it's a bit of a blurred line just because with retargeting and analyzing user behavior, typically you analyze trends over a long period of time. And so Abacus Alliance recently conducted a study analyzing 500 million transactions in the e-commerce space to measure the likelihood of a customer repurchasing with the intention of discovering how long you can actually retarget a previous customer with ads. So essentially, how long can you store the purchasing behavior of an individual under the GDPR, with the assumption that it is necessary for your service or for your offering. And so they discovered that 90% of customers that repurchased did so within 50 months. It's a bit more cut and dry for software companies. If an individual is no longer using your service, you must delete their personal information from your system. Facebook recently implemented a new policy that actually blocks apps from accessing user data 90 days after non-use. So if a user signs up for your Facebook app and they start using it, maybe they only use it for a week, 90 days after that week, Facebook will actually revoke access to their data, so you can no longer view any of their personal data. There was one other clause in GDPR that I thought was particularly interesting, which is personal data may be kept for a longer period for historical research. Again, I think there's still a bit of a blurred line here, and I think a lot of it will hopefully, come out over the next few months or the next year, and what all of it really means and kind of the implications around it. But I think in most cases, marketers specifically can kind of argue that user data is being kept for historical research because you want to analyze trends, buying behavior, different things like that actually are very important, for marketers and for really analyzing how a business is performing. This is another big topic with the GDPR, which is analytics and tracking cookies. So essentially, they broke it down into two different buckets, either essential cookies or non-essential cookies. And essential cookies are those that are used for user authentication or any cookie that's necessary for your service to work properly, and these do not require consent. So these you can continue to use without notifying the user or gaining explicit consent from them. Also, you do not need to provide a way for the user to opt out. However, non-essential cookies, such as tracking cookies or analytics, do require affirmative consent. Implied consent is no longer sufficient. So again, you can't have some text saying, by using the site, you accept cookies. That's no longer acceptable. You actually need affirmative action. The user needs to click an unticked checkbox and then confirm that they agree to your cookie consent. So you notice in the example here, the consent pop-up, all of the checkboxes are unticked by default. The text clearly explains what the cookies will be used for, and there's a link to show more details. With that more details link, you want to go ahead and link it to your privacy policy or terms of use, where you're actually talking more about how the cookies are being used within context of your entire terms of service. Not only do sites need to gain explicit consent, but they also need to have a way for users to opt out and even a way for users to delete retained data. And I think this is a really big one. It's something that's, I think, going to be extremely difficult moving forward, just because there is some sort of ambiguity for the developer and for the end user in terms of which data maps to which tracked user for third-party applications, such as Google Analytics. And so it will be interesting to see how these progress moving forward. But I know Google Analytics mentioned that they would provide a tool after tomorrow to allow a user's data to be deleted from the platform. And really, I think the powerful thing there is giving tools from these third-party apps to developers and to business owners to actually comply with GDPR effectively. And essentially what you need to provide in terms of information, in terms of the cookie policy, is what information you will be collecting with the cookie, and then also information on what the data will be used for. Sharing data. So a lot of existing websites and tools will use third-party apps to handle different aspects of the business, whether that's reporting, analytics, maybe email marketing using MailChimp or something like that. And so now moving forward with the GDPR going out tomorrow, you must provide an explicit list of sub-processors in your privacy policy, including what data you share with each of them and why. For example, if you collect email addresses via a native form on your website and then send that data to MailChimp for storage for processing, you must explicitly state that in your privacy policy. And you need to also say, why you're sending MailChimp data and what data it is that you're sharing with them. This regulation doesn't only apply to sub-processors. You can't share one user's personal data with another user. I know some existing services do this already for benchmarking and things like that. So you can compare how your business is doing, on a marketing standpoint compared to other businesses. And this is no longer okay to do unless you get written consent from the initial user whose data you're sharing. So we went ahead and asked if anyone had questions prior to the webinar, and one that came through was, does the new law affect all sectors in the same way? It's a great question. I think the biggest differentiator is really how data is stored and how long it is stored for. So for example, health and government related data cannot leave the EU. So that means that data must be processed and stored within the EU. Luckily, if you're managing your website through AWS or some other cloud providers, a lot of them do have servers in many regions around the world, making compliance much easier for you if you do work in the health or government sector. In terms of data retention, you can only store data for as long as necessary for the service that you provide, which will of course vary heavily depending on the sector that you're in. An example of this would be a dental office likely needs to keep data for years to make sure the records are accurate for making predictions for a customer, while on the other hand, maybe a clothing or e-commerce store probably shouldn't keep data for quite as long. Again, we mentioned the study done by Abacus Alliance that they discovered that most users, most purchasers will repurchase within 50 months. And I think that's kind of a good place to start as a general rule of thumb if you're in the marketing industry. Start with keeping users' data somewhere between 38 to 50 months and kind of go from there. I think a lot of this will become more clear in the coming months and coming year once some of these larger companies kind of figure out what's going on in terms of the GDPR and regulations around it. Again, the regulation still leaves a lot up for interpretation, but it's always better to err on the safe side. And again, I'll bet we'll see more stuff defined and guidelines surfacing over the next year or so. Here's a list of some resources to learn more about the GDPR. Also, I will post a copy of this webinar, a recording of it, up in the Facebook group, and I'll email it to all the participants so you can go ahead and watch it afterwards. But Facebook has a good resource for the GDPR, specifically for businesses and businesses that advertise on Facebook. So if you want to check that out, I would go to facebook.com/business/GDPR. If you want to read the actual documentation of the GDPR, you can go to gdpr-info.eu. And if you are a marketing agency and you're looking to grow on social media and manage more brands effectively, you can go ahead and give our company a check at cloudcampaign.io. If there are any questions, I will be posting the recording in the Facebook group, and I'll also email it out to anyone who RSVP'd for it. So feel free to just respond directly with questions. Thank you.